Welcome to PraDa Law Live, ladies and gentlemen. I'm Jackie Mendez, and happy Tuesday to all our viewers watching. Just as you can see, there's a number on the screen, 888-88-LEGAL. Give us a call. The call is free, and so is that consultation. I want to introduce our partners here today at PraDa Law. First up, we have the beautiful Alexis Garcia.
Thank you so much, Jackie. Hello, everyone. Hello, and it's a pleasure to be here this evening.
And of course, Daniel Silver.
How are you? Pleasure to be here. Jackie, maybe next time I can get an adjective.
Let's think of one, a good one for you. Okay. And of course, the lovely Jennifer Pratt.
Good evening. It's a pleasure to be here. Thank you, Jackie.
Beautiful. Lovely. Daniel.
Daniel, our favorite partner here at PraDa Law.
There you
ladies
go.
and gentlemen.
That's how you
I
Okay.
like to call him Dan the Man.
Dan the Man.
Dan the Man.
Danielito.
That's a good one. Well, ladies and gentlemen, once again, that number, 888-88-LEGAL. Give us a call.
That's right, Jackie. And today we're going to be talking mostly family law, but we have Attorney Garcia here. We're going to be sprinkling in some bankruptcy as well. And we have a very instructive and instrumental and very important show today, because a lot of times in these family cases we talk a lot about the he said, she said, the discovery, the this or that, but today we're going to talk to you guys about something legal that can really help make a complete difference in your case. And these are motions for reconsideration, motions for rehearing, and they're actually they're related in both family and in bankruptcy. So we're going to hear from Attorney Garcia as well as to how these kinds of motions make a difference. And start us right off. Let's get right into it, Attorney Silver. Why would somebody need a motion for reconsideration or rehearing? And let's start by explaining to people, what does that mean? What do these motions mean, and when would we use these motions?
Sure. You know, some lawyers interchangeably use rehearing and reconsideration. There are differences, but basically you're filing this, or the other party's filing this because they lost. And they want the judge to either reconsider something new, rehear some new evidence, or raise some post-judgment issues as to why whatever order or judgment was entered against them should be vacated or set aside.
Okay, so if you are someone in a family case and you have lost your case, you've lost a hearing, you've lost your case, listen up. We are talking to you today.
That's right. 888-88-LEGAL. Give us a call.
And Attorney Silver, isn't it true that just because you lost a motion or you lost your family case, that's not the end of the case? That's not the end of the road.
It certainly may not. So let's just back up for a little sec. So if you lost perhaps a temporary motion, like a motion that awards temporary support or temporary time sharing, you know, these aren't necessarily final, but they certainly can be raised in a motion for rehearing or reconsideration if you have new evidence, or basically if you lost the hearing and you want the judge to reconsider something else. And also, if you win the hearing, you need to have an attorney that knows how to defend against these motions for rehearing or reconsideration, because just because you won doesn't necessarily mean that the judge can't change their mind if opposing counsel brings up something new or unexpected or anything.
And Attorney Garcia, you were telling us that in bankruptcy, you can also file motions for reconsideration. In what kind of settings and for what reason?
Absolutely. For example, let's take it if you have a motion to value in a Chapter 13, for example, and you lose the motion to value. Motion to values are when you get rid of a second mortgage entirely, okay? You wipe it out. Let's say you're the debtor and you lose, and the judge says, no, your second mortgage has to stay. Well, I can file a motion to reconsider and, you know, maybe point out to the judge where we believe he did not rule in line with the facts or with precedent, and we can ask the judge to reconsider and say that the order should be entered instead in our favor.
Thank you so much, Attorney Garcia. Once again, 888-88-LEGAL. The call is free. The consultation is free. Attorney Garcia?
Yes, and also another context that comes up a lot more in bankruptcy, which you'll see it, is a lot of times individuals' cases are dismissed and you have an order of dismissal. And what's going to happen in these orders of dismissal is that's not the end of the road in the bankruptcy case. You have a certain period of time in which you can ask the courts to reconsider the dismissal order and to reinstate your bankruptcy case. So I see that a lot. I've dealt with that a lot, and that's something in the bankruptcy realm where you will hear those motions and you'll see them filed if you're attorney attorney knows how to properly and timely file them.
Why would my Chapter 13 case be dismissed? What are some of the reasons?
Oh, absolutely. So many. Well, there's for failing to remain current on your payments, your plan can be dismissed, your case. So you can reinstate, and there's something, besides reinstate, you have to proffer, you now have the funds available. So there's things that have to be proven within your motion. Other times it's your case is dismissed because you are not properly confirmed, meaning you don't comply with the trustee's request. So for fail to confirm your plan. And what you can do again is file the motion, but your motion always requires supplemental either actions or supplemental fees. So you really need to understand the case specifics and understand what needs to be tailored in your motion.
Okay, thank you so much, Attorney Garcia. Once again, the consultation is free. Give us a call, 888-88-LEGAL. The number is very simple.
That's right, Jackie. And so, for example, in the immigration context, when I ask for bond for someone and that bond is denied, that means the person remains detained in an immigration detention center, I am able to ask for a subsequent bond. Let's call it a motion for reconsideration, let's say for bond, but I have to bring forth different or changed circumstances. I need to bring forth that something has changed since the last time I was in court. I'll start with Attorney Silver. In family law, if I'm ready to file this motion to reconsider or rehearing, does something need to change?
Wow, that's very interesting. So if you lose at trial, you have 15 days to file your motion for rehearing or for new trial. Now, what you're maybe talking about is, let's say you lose at trial and there's some issues with child and time sharing, and let's just say a year later something changes. Then you may have a substantial change in circumstances in which you could file a petition for modification to modify the judgment. But that's a lot different than having the court reconsider or rehear the judgment that's already in place.
Right, because that's not a do-over. That's just, I took it and we're just going to change it. But for those folks that want a do-over, do they need to show changed circumstances at that point?
Well, look, it's such a difficult question. I would say that if you have a judgment, if you had a bad ruling entered against you, give us a call. Let us analyze the case. Let us see what available remedies that you have in order to either attack or vacate this judgment.
Thank you so much, Attorney Silver. Dan the man with all that information. Thank you so much. We do have to take a very quick commercial break, but once we get back, we'll continue the conversation. I want to remind everyone that the call is free, the consultation is free, and the show is live, so give us a call at any time. That number, once again, super easy, 888-88-LEGAL. We'll be right back with some more information coming from Attorney Garcia, Attorney Silver, our partners here at PraDa Law, and of course, the lovely Jennifer Pratt. We'll be right back after this message.
I know you're home right now asking yourself, how? How will I pay my rent, my mortgage, my bills, my credit card debt? I'm attorney Alexis Garcia with PraDa Law. I've personally helped people with financial problems over the last 10 years. I understand what you are going through. We saw people lose it all in the 2008 financial crisis. You don't have to lose it all. The consultation is free. Call us now. I will help protect what you have built. You have nothing to lose by calling us. Call us now. These are trying times. This deadly virus is affecting our health, economy, jobs, our small business owners. Bankruptcy protection may be able to save assets and immediately stop your creditors from harassing you. Small business owners, employees of business of any size, we know you need help. Call us now. We will help you get back on your feet. Don't wait until it's too late. This is the time to call.
Sé que estás en la casa ahora mismo preguntándote, ¿cómo voy a pagar la hipoteca, la renta, los biles, las tarjetas de crédito? Soy la abogada Jennifer Pratt con PraDa Law. Yo personalmente he ayudado a las personas con problemas financieros durante los últimos 10 años. Yo entiendo por lo que estás pasando. Vimos cómo la gente lo perdió todo durante la crisis financiera del 2008. No tienes que perderlo todo. Llama ahora. La consulta es gratis. Te ayudaremos a proteger todo lo que has construido durante todos estos años. Sabemos que estos son tiempos difíciles. Este virus mortal está amenazando nuestra salud, nuestra economía, nuestros empleos y a los propietarios de nuestras pequeñas empresas. La consulta es gratis. Llame ahora. Te ayudaremos a recuperarte. No esperes hasta que sea demasiado tarde. Llame ya.
And welcome back to PraDa Law Live. Once again, I'm Jackie Mendez. This is one of my favorite shows because we have all our partners here joining us today for the show here at PraDa Law Live. And we're going to get back right into that conversation, but I just want to remind everyone of that telephone number, that toll-free telephone number, and the free consultation that you will receive once you call it 888-88-LEGAL.
Listen up. If you have had a family case where you've had an outcome that you're not happy with, I'm not saying you're a loser. I'm just saying you weren't necessarily a winner. Listen up, this is your show. We've got Attorney Silver here talking to us about motions for rehearing, motions for reconsideration. Is there a time limit by when I have to file these motions after, let's call it a regular motion hearing?
Yeah, okay, so 15 days for motion for rehearing or motion for new trial. Reconsideration doesn't necessarily have a time limit set in stone, but it has to be timely filed. And then to attack a judgment under, newly discovered evidence or fraud, it has to be within a year. So those are the general rules. There are exceptions, and especially the biggest one, if you file a fraudulent financial affidavit in a family law case, it can be set aside or that judgment can be opened up at any time. That's why we take so much time on these financial affidavits. They're really important.
And in bankruptcy, we have very similar timelines because they come from the federal rules as well. So you have 14 days for a motion to reconsider. When your case is dismissed, you want 14 days to file your motion to reinstate your case. If it is, you can do a motion to reconsider within a year as well, but that's going to be highly scrutinized. Right. The courts in actually Dade County, in the Southern District in Dade County, are a little more liberal in granting motions to reconsider when they're filed outside of 14, but within a year. Other courts are going to be a little more strict. In Broward, they get a little more strict, and they want more facts. They want to know, why wasn't this brought in the 14 days? What are the circumstances that have changed? So you really want to be careful. If it's timely filed, all courts are pretty liberal in certain motions in granting the relief here.
So in bankruptcy, I keep hearing you say change the circumstances, which is like the same thing I got to prove in immigration court. So is that kind of the standard? You have to show something has changed?
Technically, in a lot, not all of them, but in some of them. And when your case is dismissed because you failed to turn in documents in a Chapter 13, you don't have to show a change there. You have to file your motion in 14 days and submit the documents with the filing of the motion. So there's not a change, but you need to correct your error, an error like that. But other times, it could be a change in circumstances. You changed your job, so now you can fund the plan. So it wasn't within 14 days. It's outside of the 14 within the year, but now there's funding available. So it's very case specific. Just come to our office, let us analyze where you stand in the case, and we can help you, we can guide you.
There are parallels in the family too, because the rules do provide that with scrivener's errors or clerk mistakes, that's also a ground to vacate or set aside or challenge a judgment as well.
What is a scrivener's error?
A mistake in someone's writing something. We attorneys are scriveners.
Well, and in those areas of the bankruptcy court, it's very liberal. You can have that, and sometimes that happens. You just have to clean up your docket or clean up the case, and they'll allow you to do it a year and a half, 2 years into the filing.
We dot our I's and cross our T's, but sometimes some attorneys don't. So that's why that rule's in place.
Okay, well, thank you so very much. Once again, 888-88-LEGAL. Give us a call. The consultation will be free.
I want to talk about a specific family case that my office, that we handled here a couple of months ago, and it had to do with a motion to vacate. And I know Attorney Silver already said that if you're trying to vacate, that means undo a final judgment. That means you were divorced, or in this particular case, it was a paternity action. So I'm sorry, no, it was actually a divorce. It was actually a divorce. The parties were divorced, and there was a final judgment, and the individual, it was the husband, he came to our office, and the judgment had been signed probably 3 or 4 months already had been signed, and they had been working with the agreement, working under the agreement, paying the child support, the alimony, the different things that come about it. And they came though, and basically the ex-husband at that point just was thinking that the agreement was unfair. And there were lots of terms in the agreement that, he just wasn't in agreement with, even though this was an agreed agreement, believe it or not. It didn't go to trial. I remember sharing these details with you, Attorney Silver, and you said to me, this is going to be an uphill battle. What's the game plan here?
When it comes to marital settlement agreement or a prenuptial agreement or a postnuptial agreement, because you entered into a bad bargain isn't necessarily a ground to vacate or set aside the agreement. And that's why you need to be very sure that what you're agreeing to is in your best interest. And especially when you sign an agreement, that's one thing. But once you send it to the court and the judge enters an order ratifying the agreement, it gives another layer of protection, because the public policy of the state of Florida is to uphold people's agreements.
And you'll notice, or I see a lot, and I'm sure you see it in family, whenever there's an agreement in bankruptcy, there will always be language in the agreement addressing, the parties are aware, the parties have investigated, the parties believe this is in their best interest. So on top of signing it, the parties were able to consult their own counsel. So you'll have all of that extra language in there. So things like this, it's not easy to come back around and say, no, you can't.
Freely and voluntarily, no
Right.
duress, no coercion, no
Correct.
one's pointing a gun at your head. You know, this is all part of normal marital settlement.
The boilerplate language.
And I know we have like just 20 seconds before the next break, but Attorney Garcia, in bankruptcy, we'll talk about it after the break, but I want to know if in bankruptcy, when you enter any agreement for any reason, can you also try to kick it back like in some family cases, they try to kick things back. So after the break, we've got two things I want to talk to with Attorney Garcia regarding kicking back anything in bankruptcy. And I want to continue talking about this case where the husband came and wanted a do-over. Let's be real here. That's what he wanted. He wanted a do-over. And I want to explain to you how Attorney Silver and I got this man a do-over. After the break, we'll be right back. Stay tuned.
I know you're home right now asking yourself, how? How will I pay my rent, my mortgage, my bills, my credit card debt? I'm attorney Alexis Garcia with PraDa Law. I've personally helped people with financial problems over the last 10 years. I understand what you are going through. We saw people lose it all in the 2008 financial crisis. You don't have to lose it all. The consultation is free. Call us now. I will help protect what you have built. You have nothing to lose by calling us. Call us now. These are trying times. This deadly virus is affecting our health, economy, jobs, our small business owners. Bankruptcy protection may be able to save assets and immediately stop your creditors from harassing you. Small business owners, employees of business of any size. We know you need help. Call us now. We will help you get back on your feet. Don't wait until it's too late. This is the time to call.
Sé que estás en la casa ahora mismo preguntándote cómo voy a pagar la hipoteca, la renta, los biles, las tarjetas de crédito. Soy la abogada Jennifer Pratt con PraDa Law. Yo personalmente he ayudado a las personas con problemas financieros durante los últimos 10 años. Yo entiendo por lo que estás pasando. Vimos cómo la gente lo perdió todo durante la crisis financiera del 2008. No tienes que perderlo todo. Llama ahora. La consulta es gratis. Te ayudaremos a proteger todo lo que has construido durante todos estos años. Sabemos que estos son tiempos difíciles. Este virus mortal está amenazando nuestra salud, nuestra economía, nuestros empleos y a los propietarios de nuestras pequeñas empresas. La consulta es gratis. Llame ahora. Te ayudaremos a recuperarte. No esperes hasta que sea demasiado tarde. Llame ya.
Hello and welcome back to PraDa Law Live. Once again, I'm Jackie Mendez. We've been talking a little bit about bankruptcy and some family laws. Ladies and gentlemen, there's a number. It's on the screen. It's 888-88-LEGAL. That call is free and that consultation is free. We have offices in Miami, in Doral, in Colombia. So
You said that so good.
yeah. So give us a call. You have nothing to lose. Let's get back into the conversation.
We're international, baby. So we were talking before the break regarding the changed circumstances and things that whether or not in bankruptcy, how difficult it is, Attorney Garcia, to try to undo an agreement. That's what we're talking about here, and we're going to talk about it on this next segment regarding family law. Can you undo an agreement?
I mean, you can attempt to undo anything you've entered into. You know, you can always make that attempt. Now, what are things that may make it easier? Well, did you enter into the agreement pro se, meaning not represented by a debtor and a counsel, and then later when you secured counsel, realized the mistake you made? Right. Now, again, that may not get you out of it, but maybe that's a little bit of leverage that your new counsel could bring to the judge saying, you know, you didn't understand. Yes, you signed this, but you had 2 attorneys and the credit, you know, there was a lot of things going against it. Not that that's a slam dunk in any sense, but you know, you have maybe a leg to stand on. Or maybe you discover some information later after the fact that was, you know, that was not disclosed when you entered into the agreement. So I don't know necessarily if you're at that point, it was really fairly agreed upon because you weren't given all the information.
And I'm sure things like, and this is probably across the board, things like competency, whether the person was competent to enter, like
But
were
should they be in bankruptcy if they're not competent to enter into an agreement? Then, you know, so those are all right.
And then we might want to be careful raising that in a bankruptcy because
because if you're going to raise that, they're not competent. Now, there's ways to get around that. You can maybe have a guardian appointed within the bankruptcy, much like you can do in state court. So that's just opening up a whole other box, but potentially, and then you'd have to correct that as well.
And then you're mentioning not knowing all the facts. I want to talk about that, Attorney Silver. I want to go back to our do-over case, but I have to bring this up because it's in line with what we're talking about undoing agreements. Post-nuptial and even pre-nuptial agreements, Attorney Silver. One of the things we have to do is disclose our financial information. Both sides have to provide their financial information. What happens if once we're getting divorced, I find out that you did not give me all your disclosures or that you lied when we signed that prenup or postnup? What happens then?
Then the attorney representing you at that time is doing a double facepalm because they didn't do their job. But point being, it is
well, what if that person just hid it from everybody?
Well, then it's certainly.
This is what I'm talking about. I'm talking about that you and I signed a prenup, and I failed to show you my $10 million brokerage account.
That prenup could be so articulately, perfectly drafted.
Right.
It's not worth the paper it's printed on. You know, there Florida statutes on the prenuptial agreements basically have the. I was going to say the statute, but you don't want to hear it. 61079. But there are just disclosure requirements, and also there are also other requirements that say that the agreement can't violate Florida public policy, in that you can't basically have someone enter into a prenuptial agreement and then have no support and be put on food stamps. So, you know, there are certainly rules and regulations, and you got to disclose everything. Otherwise, it's the agreement's done.
Otherwise, I can try to undo it.
Oh, and it's going to get undone. There's case law that I've seen where someone doesn't disclose a pension and the agreement and the prenup marital agreement's done.
That's kind of along the lines too. If you have agreements with Chapter 7 trustees, whenever you have an asset Chapter 7, the Chapter 7 trustee will always include language stating, you know, this agreement is based on what we uncovered and what was disclosed. If in the future the trustee discloses additional assets or accounts that were hidden, you know, at that point, that agreement is not going to stand either.
And Attorney Silver, what if we get divorced? There was no prenup, there was no postnup, it's just a regular divorce. And after the divorce, I find out that you hid assets in the divorce that presumably I would have been entitled to some percentage or interest. Can I try to undo the final judgment based on that?
Absolutely. What we would do is we would look at the financial affidavit that was filed by the opposing party in that case, basically say that, hey, you know, this financial affidavit lists $500,000 worth of assets. However, we find an account where there's $300,000 that's not disclosed. It could be 20 years later, you could set that thing aside.
That tricky financial affidavit, that's also relevant in bankruptcy court too.
Well, right, we don't have a specific form affidavit as
the same one. You guys use it too sometimes.
We do use it. We do use it to compare to what you're submitting. Well, I use it when I do my due diligence for my clients. I use it to compare to make sure my clients are giving me everything and there won't be any conflicts.
Hey, check this out. If you go through a divorce and you file a financial affidavit in that case, you can bet that anytime you're ever involved in any sort of civil litigation the next 10 or 20 years, that opposing party, they're going to the court file, they're getting that financial affidavit. Wow. It's public records.
Okay. Well, thank you so very much, attorneys. Once again, 888-88-LEGAL. Give us a call. The consultation is free.
Can we have that redacted in the court file, the financial affidavit?
You know, I mean, technically, I guess the court would have the jurisdiction to do it, but technically, no. I mean, you know, financial affidavits are filed every day, and they're not, you know, redacted or confidential.
We've got about a minute left, and I promised you guys that I also want to talk to you about the do-over case. The do-over case, basically, Attorney Silver said was, you know, a total loser. Said I was just not going to be able to win this.
We're going to say that.
But I want you to know, long story short, we got this husband or former husband a do-over. I didn't step into court, not once. It was just called great negotiations. And I have to admit, the former wife had great attorneys that worked with me, and that, you know, we were able to come together and basically redo certain terms of that agreement. And it was very cost effective, and it was amazing. 30 seconds, appeals. We literally have 30 seconds. We do appeals in our office.
We do appeals, but
how long after the final judgment is entered?
30 days, you have to file your notice, but there's so much work to be done, and really, what I do want to add is this. You need to make sure that your trial attorney knows about appeals, because if you don't object to something at trial, you may waive it on appeal, and that's terrible.
And you need a court reporter.
Always have a court reporter.
Always have a court reporter.
Always have a court reporter.
Okay, well, can't believe the show's already over, guys.
I can.
Okay.
Let's go.
Well, I want to thank all our partners here at PraDa Law Live for joining us today. Of course, Alexis Garcia, Daniel Silver, and Jennifer Pratt. We thank you guys so very much. To all our viewers watching, 888-88-LEGAL, that's the number you need to call. That consultation is free. We have offices in Miami, in Doral. We'll see you guys tomorrow. Have an awesome day.